Hi all, welcome to our webinar on the EU Data Act. In this webinar we will outline the scope of the Data Act, explain its key requirements and highlight the practical step organizations should take to ensure compliance with the Data Act. My name is Verhoeven and I'm a lawyer at the Digital, Cyber and Privacy practice at HVG Law. I specialize in digital law with amongst others a focus on the Data Act. I'm joined today by Lukas Willinge.
Hi all, Lukas Willinge. I also used to be a lawyer in the Digital, Cyber and Privacy practice at HVG Law, but I'm now a manager at EY in the technology consulting team, more specifically on cybersecurity and privacy. Let me start by walking you through the agenda for this session. First, we will begin with the background of the Data Act to set the context. Then, secondly, we will cover the timeline of the Data Act and where we are now. Third, we explain the scope and relevant actors of the Data Act. Fourth, we then dive into highlighting some of the key requirements, including providing practical tips for implementation. Fifth, we briefly address enforcement and fines. And then finally, we conclude with next steps and discuss what actions organizations should take moving forward. The Data Act is part of the European Strategy for Data, which aims to create a single market of data across the EU. The strategy is designed to ensure that data can flow freely within the European Union, across sectors, and between businesses, governments, and citizens. The aim is to harness the potential of the ever-increasing amounts of data for the benefit of the European economy and society by trying to remove boundaries for sharing data. The Data Act itself creates new rules on who can access and use data generated in the EU across all economic sectors and aims to remove barriers to access that data. The Data Act also aims to ensure fairness in the allocation of value from data among actors in the digital environment, to stimulate a competitive data market, and to open up opportunities for data-driven innovation and make data more accessible. Also, the Data Act is actually a regulation, which means it applies directly in all EU member states without the need for national implementation.
The Data Act is organized around 5 objectives, each implemented in specific chapters of the Data Act. I have provided an overview on the slide. So one of the first topics that addressed is facilitating data sharing by giving access to and the use of data by consumers and businesses. The second one will be making available data for the use by public sector bodies in situations where there is an exceptional need for data in the public interest. The third topic will be facilitating switching between digital services processing data services. The fourth one will be introducing safeguards against unlawful data transfers without notification by service providers. And the fifth one will be providing for the development of interoperability standards. These objectives can be grouped into 2 key themes the Data Act covers. The first theme will be the framework for data sharing across the European Union. This applies to business data sharing, business to consumer data sharing, and business to government data sharing. And the second one will be the facilitating of the switching between providers of data processing services by taking away barriers that may hinder switching between cloud services. Users are also able to combine their cloud service more easily, as services can be connected more easily. This is referred to as interoperability. Today we will do a deep dive into the framework for data sharing, because these obligations have a very wide scope and affect a broad range of organizations across different sectors. Examples of sectors include the industries such as the manufacturing industry, energy, mobility, transport, logistics, and even the food supply chain. So where are we standing now? On the slide you can see the timeline for the Data Act. The Data Act entered into force into January 2024. Today, most of the obligations of the Data Act already apply. These apply since 12 September 2025. It's therefore time for organizations to comply with the Data Act now. There are 2 exemptions. This regards to the provisions relating to the access by design obligation and some provisions related to unfair contractual terms to contracts concluded before on or before 12 September 2025. Those will become applicable at a later stage.
Before we dive into the requirements of the Data Act, let's take a look at its scope and the key terms and elements. In the chapters that set out the framework for data sharing, we have two very central terms, which are related product and related service. Related products are items that generate, obtain, or collect data about their use, performance, or environment, and that can communicate this data via a cable-based or wireless connection. Related products can therefore be found in all areas of the economy and society. Examples include connected cars, smart home devices, consumer electronics, industrial machinery, but also health monitoring devices and planes. A related service, however, is a digital service that can be linked to the operation of a collected product and that can affect the functionality of this collected product. For instance, by transmitting data or command to it. Two basic conditions must be satisfied for a digital service to be considered a related service. That is that there must be a two-way, bidirectional exchange of the data between the connected product and the service provider. And the service must affect the connected product's functions, behavior, or operation. Examples are an app to adjust the brightness or to regulate the temperature of a fridge. Another example is a user that buys a washing machine and installs an application to allow the measure of the environmental impact of the washing cycle based on the data from the different sensors inside the machine and adjust the cycle accordingly. This application would be considered a related service. Several factors determine which data are covered by the data access and are rights provided for in the Data Act. Generally speaking, raw but usable data generated from the use of a connected product or related service that is readily available to the data holder. In other words, data that can be easily accessed without disproportionate effort, going beyond a simple operation. Several types of data are relevant here, which are also displayed on the slide. So we have the product data and data from a related service that is readily and lawfully obtained by a data holder, or that can be readily and lawfully obtained without significant effort. Then the user data resulting from user interaction with a connected product or related service. This user data can then be divided into three subtypes. The product data, raw, unprocessed data collected directly by the connected product for its use, its performance, or the environment in which it's located. The product data may be retrieved by a user, data holder, or third party, including the manufacturer, through an electronic communication service, physical connection, or direct access to the product. An example would be that the current room temperature is 21.5 degrees. Then we have the data collected by related service, which is the second bullet. Data generated by the user's interaction with the connected product or through the provision of a related service itself. Example would that be energy consumption, for instance. And metadata, that's the last bullet in the slide. Data that provides additional information about the product data, enabling the related service to interpret and use it correctly. An example of this is time of measurement, March 10, 2025, 2:05, for example. If a user watches a film on their connected TV, the data on the brightness of the screen is within scope. However, the film itself is not within scope. So there's also a lot of data which is not really in scope, which is data which is already on the device, data, as previously indicated, which is not readily available, therefore requiring disproportionate effort, inferred or derived data, so where there has been additional investments into assigning values or insight, trade secrets, and data which disclosure would compromise security.
Important to note is that personal data is also in scope of the Data Act. Using a connected product and a related service may also result in the processing of personal data. For example, you can think of the IP address which is processed of the user, and then the GDPR will always remain fully applicable to all personal data processing activities also under the Data Act. Users' rights provided by the Data Act therefore have to be exercised in compliance with the GDPR. For example, personal data may only be processed if there is a valid legal basis under Article 6 of the GDPR. In the event of a conflict between the GDPR and the Data Act, the GDPR will always prevail. The Data Act introduces different obligations depending on the role that an organization has. Therefore, there are some relevant actors in the Data Act which are important to define and also important to define what role your organization has. So on the slide you can see an example of a situation where the Data Act applies to. And here you can see, first of all, the manufacturer, which is the company that produces a connected product. And on the right, the related service provider, which will be a provider of a related service. The Data Act applies if a connected product or a related service is placed on the EU market. This refers to placing the product on the European market for the first time. And that is the case, for instance, when a product is sold for the first time in a member state. The Data Act can therefore also apply to manufacturers established outside of the EU if they place their products on the EU market. Then there's also the user. And the user can be an individual or an organization with the right to use a connected product or receive a related service. And that right can be, for example, based on a sale, rent, or lease. Or for a related service, the right can be based on a service provision contract. It's important to note that the user can be both an individual or a business. And examples of users are then, for example, consumers who have smart thermostat in their homes, hospitals that own an MRI scanner, and farmers who rent smart tractors. For the user, the Data Act only applies to the user if the user is established in the European Union. And then also an important actor within the Data Act is the data holder. The data holder will be the person or the organization that, often by contract, has the right or obligation to use or make available data. Often, the data holder will be the manufacturer of the connected product or the organization offering the related service. But it can also be another party. Determining who the data holder is depends on who controls access to the readily available data. And also note that there can be more data holders in relation to one connected product or one related service. The user must always be informed of the identity of the data holders. And then lastly, as you can see on the slide, there are several data flows within where the Data Act can apply to, and then there's also the third party or the data recipient. And the third party can be an individual or an organization that receives data, and this can be via the user or via the data holder. And the third party could be an organization that uses the data it receives to develop a related service, conduct scientific research, or provide aftermarket services. And an example of aftermarket services would be maintenance and repair services for connected products. Think of a third-party mechanic servicing a car. Next up, we will highlight some key requirements following from the Data Act's framework for data sharing. And so one of the main first obligations, which is important to note, is the obligation to provide information. The Data Act imposes specific transparency obligations on providers of connected products or related services. On the slide, we have included the list of information that must be disclosed to users of connected products or related services. As you can see on the slide, the list for connected products and related services are similar, but not the same. The list for related services is actually longer. And as you can see, the information that must be provided includes which type of product data, the format of the product data, the estimated volume, the ability to generate data continuously and in real time. And for the related service, that will be, for example, the type and estimated volume and collection frequency of the product data, the expected use of the readily available data by the data holder, the identity of the data holder, as I just discussed also, and also the right to file a complaint with the competent authority, and some more information on trade secrets and their holders. When must this information be provided to the user of the connected product or the related service? The information must be provided prior to entering into the agreement to purchase, rent, or lease the connected product or to provide a related service. And then who is responsible for providing this information? If it regards a connected product, the seller, the renter, or the lessor of the product is the party that is required to provide this information. And this can also be the manufacturer itself, but it does not have to be if there is a chain of more organizations who sell the product. And in the case of a related service, the provider of the service is responsible for the disclosure of the information. Now Lukas will provide some practical tips for implementation.
Yes, so that of course is what the law says, but as stated by Robin, I mean there's a transparency obligation requiring information to be provided, but how did you actually provide this? So first, a more general note, that is that national data protection authorities, such as the Dutch Data Protection Authority, Autoriteit Persoonsgegevens, as well as the European Commission, has documentation available to help you with implementation. So for here, it states that, for instance, also in the second enforcer of the Data Act, which would be the ACM in Dutch, has also issued guidelines where it says that you can provide the information multiple ways. So you can link it through a website, as you can see on the slide, but also provide it physical or digital manual, provide a QR code, or actually via a contract. So there's multiple options available here.
Then another important obligation following from the Data Act is the obligation to provide access of the data to the user. The Data Act provides two regimes for providing mandatory access to the data for the user. The first one will be direct access, or also called access by design, and the second regime will be indirect access, which is also called access upon request. So for the first regime, that will be direct access, and directly accessible means that the user can export the data without the involvement of other parties, so that the user has the technical means to do so. Direct access could then also be remote access, but it actually means that the user does not have to request access to the data, but it already receives the access. For example, a connected product that has a digital interface where the user has control over the access mechanism, where the user can directly extract the information and the data from the connected product. And who is responsible to provide access? Well, the access obligation applies to the party responsible for the design and production of the connected product or the related service, and that will be typically the manufacturer or the designer of the product. Then the second regime will be the indirect access or the access upon request. So if direct access cannot be provided, the data holder must make the data available upon the user's request. So upon receiving a request for indirect access, the data holder must provide the user with immediate access to data of the same quality as the data it has access to itself. This applies both to requests to share data with the user themselves and to requests to share data with third parties. The user must always be able to request access electronically through a simple process. And then an example would be a web portal where the user can submit a request to access data. Then is an organization allowed to refuse to share some data? Well, the Data Act includes also two grounds on which a data request can be denied, and those will be, first of all, security risks, and second of all, trade secrets. So first of all, the security risk. The data holder and the user may contractually agree to restrict access in case of an event of a serious threat to the security of the connected product. And secondly, with regards to trade secrets, data from a connected product or related service may of course contain trade secrets, and that's information that the data holder needs to protect. The Data Act therefore states that trade secrets do not have to be disclosed if sharing undermines the confidentiality of the trade secrets, especially with regards to third parties.
Yeah, so then on the slide you can actually see, so what is the choice there for the data holder? So there's actually two. You can either amend the product design to provide direct access if technically feasible, or adapt the products and services to address requests for indirect access by users. So there's some flexibility. The main point there is that they also decided to implement some flexibility is because in the end, it's also because not all products are designed in such a way to make the data directly accessible to users, and that there may be situations where data holders prefer to offer indirect access to the data. And the Data Act incentivizes data holders to put in place solutions that work best for them. They have to comply with the obligation of making the data available.
And then the Data Act also sets out very specific rules for all parties involved in the permitted use of the data, in addition to regulating what agreements parties might have to conclude. And we have highlighted some of those obligations with regards to the data sharing framework on the slide. So first of all, there are some notable obligations for data holders. Please note that this is not an exhaustive overview, but we highlighted some obligations that we think that might be very relevant for organizations coming up. So the first of that obligations will be that the data holder is actually obligated to only use readily available data on the basis of the contract with the user. So there must always be a contract between the data holder and the user if the data holder wishes to use the information and the data that is that comes from the use of the connected product or the related service by that user. And then secondly, data holders shall not make available non-personal product data to third parties for commercial or non-commercial purposes other than the fulfillment of their contract with the user. So this is also one thing that you should include with in your agreement and in your set of contracts. And then if one or more third parties are granted access to the data holder's non-personal product data, the data holder must clearly specify in the contract that these third parties may not share this data with others. And where in business-to-business relations, a data holder is obliged to make data available to a data recipient, this must be governed by a fair, reasonable, non-discriminatory and transparent agreement. And next to these terms for data holders and obligations for data holders, there's also some obligations which are notable for users and for third parties. So for users and third parties, the obligation applies to the user or third party granted access to the data following a request under the Data Act may not use this data to develop a connected product that will compete with the connected product from the data from which the data originated. And then also the user and third party are not permitted to use the data to gain insight into the financial situation, assets, product methods, or their use by the manufacturer or the data holder. And then one more obligation specifically for third parties. A third party may only use the received data for the purpose authorized by the user and within the conditions agreed with that user.
So, how does this then translate into practice? First of all, make sure that there actually is a contract in place containing the elements listed on the slide. So there's a contract between a data holder and a user which has to be in place. That contract needs to state that there's permission for the data holder to use the data. Also, make sure to include restrictions on the use of the data by that user. And make sure your data is kept confidential, so include confidentiality. This is just one example of a contract very specifically between the data holder and the user. But there also, for instance, needs to be a contract between a data holder and a recipient. On this, some help is provided, luckily. So model contracts will be issued by the Commission, and these are currently actually published in draft, so you can already take a look at them. Note that these might change though. And these model contracts can provide a very good starting point for either drafting your own contracts or for revising and checking your existing ones.
And then take a look at the enforcement and the fines of the Data Act. So, with regards to enforcement, member states will all designate one or more competent authorities responsible for enforcement of the Data Act. In the Netherlands, this has already been decided. 2 supervisory authorities will be designated to enforce the Data Act together. So the main enforcement of the Data Act will be the responsibility of the Netherlands Authority for Consumers and Markets, also the ACM in Dutch. And the ACM will be the primarily regulator of the Data Act. And then secondly, there's also some regulatory powers for the Dutch Data Protection Authority. The Dutch Data Protection Authority will enforce the provisions that are connected to the GDPR. And then you can think of, for example, complaints about sharing a data set that also contains personal data, as we discussed previously. And in the coming months, the ACM also stated on its website that it will focus heavily on education of the Data Act. And the ACM also noted that there's one important point for attention, and that will be, according to the ACM, that business must offer transparency to consumers and other businesses about the data that is collected and about the way in which access to such data is given. So that will be a good starting point for every organization to ensure compliance with the transparency obligation. And then what about penalties? So the Authority for Consumers and Market is authorized to impose an administrative fine up to a maximum amount of more than 1 million or 10% of the offender's total turnover, actually whichever is higher. And then the Dutch Data Protection Authority can also issue fines, and those fines are similar to the GDPR fines, which can be up to 20 million or 4% of the total annual turnover, whichever is higher.
Yes, and now next steps. So what action should you as an organization take to prepare, or actually it's already into force, or to start implementing the Data Act and make sure you comply? Well, first, of course, you need to make sure that you assess the applicability of the Data Act. So you need to look at what products or services might actually be in scope and where you need to focus on. 2, set up a project team, and also in brackets there is interdisciplinary, because you cannot do this simply with compliance or legal. You also definitely need technical teams to be integrated there, because you really need that information on, for instance, the feasibility of the connected product to provide direct access. 3rd, create an overview, determine what actions need to be taken, and establish a roadmap for implementation. Then, of course, also you need to do these things, but how can we actually support you? So there are a couple of things where hopefully we can provide some assistance, and that would be 1, help assess applicability. So make a good overview of what parts of your organization are or are not actually in scope, following which actions. Then we usually do an impact analysis, followed by analyzing which gaps you have, so making sure that you know what you need to do to comply. Then we translate those into an implementation roadmap, so there's a very clear structured plan, what you actually need to take for compliance, and when, and also how. Those were 2 more overarching items, I would say. Then some very specific items. So 3, advice on product design. As Verhoeven has indicated, access must be provided, either directly or indirectly, and we can help with establishing the data access requirements. 4th, we can assist with draft or revising existing documentation, contracts, notices, policies, etc. 5th, very important, is that we can also help with identifying and protecting trade secrets. Yes, you need to provide some data. Please first make sure that you identify which data you do not have to provide, as some can be very relevant and it can even be your crown jewels. Lastly, happy to assist you with any disputes on, for instance, data access, or if actual terms are fair, reasonable, and non-discriminatory. That was what we had to say today. Thank you all for joining. If there are any questions, feel free to reach out via email, which we will provide later, or via LinkedIn, and hopefully we can provide you with some more assistance and actually help you with implementing the Data Act. Hopefully everything was clear, and thanks for listening.
Thank you all for joining.